So the first thing to do really is to, when discussing easements generally, is deal with some basic points. And some of those basic points including, if we're acting for a buyer, identifying client objective. So if we're acting for a local authority, a commercial client, or residential client, or indeed anyone else, the important thing to ask ourselves is, well, just why are we buying this property? What's the purpose sitting behind the transaction? And then once we've decided that, it's important to ascertain if there are easements that will be necessary to facilitate that objective. So do we need rights of way? Do we need the right to connect to drains or services? Do we need a right to light? Do we have to have parking rights, etc.? All of these things need considering. So obviously, there's the question of whether or not the land that we're acquiring has the appropriate easements to facilitate our client's objective. That's fairly obvious, but you'll be amazed as to how often a conveyancer forgets to ask a client about an objective, or what is quite common as well, that you assume that the client's objective is that this is a residential acquisition or this is a commercial acquisition. And the reality will be that there's a twist or a nuance with regard to the acquisition that we're not aware of. So I might be buying this house to live in myself, but I might also intend to build an office or to convert the garage into an office. Quite common these days. I might, as a commercial client, be wanting to buy a piece of land to construct, I don't know, a warehouse or something of that nature on it, but I might also have another purpose sitting behind it. So I might be wanting to develop part of the site for another purpose altogether. We need to identify client objective and then check whether there are easements that will facilitate or enable that objective to be achieved. And we also need to think about whether the land that we're buying is subject to easements, whether easements have been reserved for the benefit of other land that are going to impact on our client's objective. So if I'm buying a property, and one of the reasons I'm buying it, it has a lovely garden, I'm not going to be particularly impressed if a next door neighbour has a right on foot right the way across the middle of the garden to access a public footpath on the other side of my property. So we need to think about easements that have been reserved. Ideally, when we're dealing with granted or reserved easements, we want to see them expressly granted or reserved. In other words, contained in a deed. Because if that is the case, then we can, generally speaking, check quite easily enforceability. And in addition to that, we will hopefully see issues such as repair, maintenance, etc., of the right of way, of the drain, being taken care of in the deed that creates or reserves the easement. If you're going to go to the trouble of creating a deed dealing with a right of way, you are going to think about repair and maintenance. You're going to think about the extent of the use of the right of way, who can use it and for what purpose. So express grant and reservation is our ideal. In those circumstances, for an easement to be a legal easement, it would require registration.